This week, I'm talking about doing an annual legal checkup on something valuable every business has: intellectual property. That's right, all businesses have intellectual property, and for many businesses, intellectual property is the business. Your brand name, your logo, your proprietary processes, your creative content, they're often the most valuable assets you own. Despite all that truth, most business owners have no idea, number one, that they even have IP, number two, what IP they actually have, number three, whether their IP is protected, or number four, when critical deadlines are coming up. That changes today. I'm Julie King with King Patent Law, and today I am walking you through a complete IP audit. By the end of this video, you'll have a much better knowledge of exactly what intellectual property you have, whether it's protected, and what needs your attention this year. Now, for each kind of IP, I've created a free, downloadable, and printable checklist you can use to make sure you're looking at everything I'm talking about today. It's on my website, kingpatentlaw.com, and I'll show the QR code for it a few times in this video. So let's get started. First, a quick refresher. Intellectual property includes patents, trademarks, copyrights, and trade secrets. Patents protect inventions, trademarks protect brand identity, copyrights protect creative works, and trade secrets protect confidential business information. The question isn't whether you have IP, it's whether you're protecting it. Now, why does an annual IP audit matter? Well, it's because your business evolves. You create new content, launch new products, expand into new markets. Your IP portfolio needs to evolve with all of your changes. An IP audit helps you identify what you own, verify your protections are current, spot gaps before competitors do, and prevent loss of rights. All of that can help increase the value of your business. This connects directly to last week's business checkup. You've verified your corporate housekeeping is solid, and now we're making sure your most valuable assets are protected. Let's start with trademarks, the most common and often most valuable form of IP for small businesses. A trademark is any word, phrase, symbol, design, or combination, or some other things that are less common, like a signature scent, sound, or packaging, that identifies and distinguishes your goods or services from others. It's how your customers recognize you. Business owners often say to me, "The Secretary of State cleared the business name when I registered my LLC, so I'm good, right?" And my response is always not at all. They only checked the list of other LLCs and corporations in your state. They didn't even check their own trademark registry, let alone the federal one. I can say with certainty that this shocks even many business lawyers, not just business owners. I found that out when I taught an IP issue spotting class to members of a local bar association. That was the moment I dedicated myself to making it easier for small business owners and other lawyers to know about fundamental IP issues and what to do about them. So let's look at your trademarks now. First, let's go over your brand names and logos. Make a list of everything that identifies your business name, product or service line names, taglines and slogans, logos and design marks, and any other distinctive branding elements. These are your trademarks. Now ask yourself these important questions. Number one, what have you registered? Have you registered any of those with your state trademark office, the United States Patent and Trademark Office, or USPTO, or internationally? Is what you've registered enough? Do you need to register more? What would be a serious problem for a competitor to copy? Are your registrations active? Make sure they haven't expired because no one submitted renewal documents or paid maintenance fees. Question number two is, what are you actually using versus what's registered? I see this constantly. Businesses that registered their trademark years ago but have since evolved their branding. Maybe you registered, for example, King Business and Patent Law, but now you're operating as King Patent Law. That's a different mark, and your old registration doesn't protect the new name. Or maybe you registered your word mark, but not your logo, or vice versa. Sometimes there's logo creep or name creep. Now, those aren't some sort of Scooby-Doo type cartoon villains I am now thinking of designing and in the style of my Old Town Chicago called dibs on LP rights to. I should note that that kind of talk is profoundly legally insufficient. They're when over time your use of the logo or name changes just a little bit here and there until there's a pretty big discrepancy between what's in use and what's registered. Your registration needs to match what you're using in commerce exactly. If they don't align, you don't have the right protection. So you either need to update your usage or file new applications. Some attorneys, including me, offer auditing services that help make sure you aren't suffering from logo or name creep or other use problems and help you know when new registration is necessary. Question 3. Have you expanded into new product or service categories? Trademarks are registered in specific classes of goods or services. When you filed your original application, you listed what you were selling or offering at that time or what you were planning to sell or offer within a very short period of time. Over time, though, businesses evolve. Maybe you started as a bakery, which would be Class 30 baked goods, and now you also sell bakery equipment, which is Class 21 for kitchen utensils. Your original trademark registration doesn't cover the new category. You need to file for expanded protection. Question number 4. Are you using the Circle R trademark symbol correctly? This is one of the most common mistakes I see because you can use the Circle R trademark symbol only with federally registered trademarks, not even with state registered trademarks. If your trademark application is pending but not yet registered, you cannot use the Circle R. If you never filed a trademark application at all, you definitely cannot use the Circle R. Using the Circle R when you're not entitled to it can get your trademark application rejected, expose you to claims of fraud, and undermine your credibility. If your mark isn't registered, you can use TM for goods or SM for services to indicate you're claiming common law trademark rights, and you should, but don't use that Circle R unless you have an actual registration certificate from the USPTO. Now let's talk about your domain names and social media handles. Your online presence is part of your brand identity, and it needs to be protected like it is. Here are the questions you need to answer. Question 1 is, do you own the domains that you need? This should be obvious, but I've seen businesses build an entire marketing campaign around a domain they don't actually own. Check who owns your primary domain, which is usually yourbusiness.com. It should be you. Check also whether you've registered the relevant variations, such as .net, .co, .io, or any other industry-specific extensions. Check whether your domain registration is set to auto-renew. Make sure it doesn't expire. And check whether someone else owns confusingly similar domains. If you don't own your primary domain, you're vulnerable. If your domain registration lapses, domain squatters will grab it and hold it for ransom. There is a certain very popular domain name seller and host that is notorious for this, and that's why it's a good reason to not even search domain names on their site. Question 2 is, are your social media handles consistent with your trademarks? Ideally, your business name, trademark, and social media handles should all match. However, social media platforms operate on a first-come, first-served basis, which means someone else may already have your handle. So check all major social media platforms. Even if you don't use a particular platform, you should still check it out and claim your handle so someone else can't harm your brand or confuse people. If someone else has your handle, you do have a few options. The first is reach out and try to acquire it. Sometimes people will sell or transfer inactive handles. You could also use a variation that's still clearly identifiable, such as @YourBusinessOfficial or @YourBusinessHQ. If the other person is using the handle in a way that infringes your trademark, you may be able to file a complaint with the platform that will result in them having to turn it over to you. Question 3 is, are other businesses or trademark squatters using confusingly similar names? Search for variations of your brand name on social media, domain registrars, and the USPTO trademark database. Are competitors or bad actors using similar names or identical names in ways that could confuse your consumers? If you find infringement, you may need to send a cease and desist letter or file a trademark registration opposition or cancellation proceeding. Don't ignore it, though. The longer infringement continues, the harder it becomes to stop. That's not it for trademarks. Trade dress refers to the overall look and feel of your brand, the visual appearance that makes your business recognizable. This can include product packaging design, store layout and decor, website design and color schemes, distinctive product shapes or configurations, and other less common brand identifiers. Trade dress is harder to protect than traditional trademarks because you have to prove it's distinctive and non-functional. Now, I did some posts on non-functionality this last year, so check those out to learn more about what that means. If you have a truly unique visual identity, it may be worth pursuing trade dress protection. Some classic examples of trade dress are the distinctive shape of a Coca-Cola bottle, the interior design of an Apple store, Tiffany & Company's signature blue box, Louboutin's red soles on their shoes, or the scent of Crayola crayons. That's called a sensory mark. If your brand has a distinctive look that customers associate exclusively with you, consider whether trade dress protection makes sense. That's a lot to think about, and that's just trademarks so far. And that's why I created that free downloadable printable checklist you can use to make sure you're looking at everything I'm talking about today. It's on my website at kingpatentlaw.com. Now let's move on to copyright. Copyright protects original works of authorship, things you create and express in tangible form. For most businesses, that includes website content, your text, your images, your videos, blog posts and articles, marketing materials such as brochures, ads, and graphics, software code and product documentation, photographs and illustrations, music, if your business creates it, videos and multimedia content, and training materials and educational content. The cool thing about copyright is that it exists automatically the moment you create something original and fix it in tangible form. You don't have to register it for copyright to exist. However, and this is critical, registration unlocks powerful enforcement tools. So look at what you've created or used in the last year. Start by inventorying everything. First, look at content you published, like blog posts, articles, newsletters, social media content, such as posts, videos, and graphics, website copy and design, marketing emails and campaigns, and print, digital, and video ads. Next, look at other materials you developed, such as product documentation, user manuals and guides, training materials, presentations and slide decks, and internal processes and workflows if they're documented. And finally, look at other creative works, like photographs, whether you took them or hired a photographer, illustrations and graphics, videos and podcasts, music or audio content, and software code or scripts. Once you have your list, ask yourself, which of these assets are valuable enough to the business that you'd want to enforce your rights if someone copied them? Now, copyright exists automatically, like I said, but registration with the U.S. Copyright Office gives you important critical advantages. You cannot file a copyright infringement lawsuit in federal court unless you've registered the copyright. Period. No registration, no lawsuit. Registration creates a public record of your ownership, too. This makes it much, much easier to prove you own the work if someone challenges you. If you register within 3 months of publication or before infringement occurs, you may be eligible for statutory damages and attorney's fees. This is huge. Proving actual damages, which are your financial losses, in copyright cases is difficult and expensive. Statutory damages allow you to recover between $750 and $30,000 per work, up to $150,000 if the infringement was willful, without having to prove your actual financial losses. Without registration, you can only recover your actual damages, which you do have to prove, and you have to pay your own legal fees even if you win. So, what is worth registering? You really don't need to register every single thing you create. Registration costs money, $65 per work for online registration, $85 for a collection of work, and that's not including attorney fees if you have one to help you. So you do need to be strategic. Focus on registering these. High-value content that took significant time and resources to create, content you'd be willing to sue over if someone copied it, your flagship creative works, your signature pieces, your most popular content, works you're licensing or selling, it's especially important you register those, and content that could be easily copied and monetized by others. You probably don't need to register one-off social media posts, internal documents that will never be public, content with a very short, useful life, routine business communications, or content that is frequently updated significantly. Now, if that list of things to register is too expensive for your business, for most small businesses, I can recommend registering your website as a whole, and you can register it as a compilation, your top 5 to 10 most valuable pieces of content each year, any creative works you're monetizing directly, such as books, courses, designs you sell, and software code or apps you've developed. Now let's go over ownership. Copyright rights require ownership clarity. Who actually owns what was created? This is where many businesses get into trouble. If an employee created something as part of their job, the business usually owns it. Now, there are some exceptions for certain creative professionals. If an independent contractor created something for you, however, they own it unless you have a written agreement that assigns the copyright to you. Now, this is critical. Let's say you hired a designer to create your logo. You paid them. You've been using the logo for years. You assume you own it. But if you didn't have a written agreement that explicitly assigns the copyright to your business, guess what? The designer still owns it. They could theoretically license it to someone else. They could prevent you from using it. They could sue you for infringement even. I've seen this following exact scenario play out. A business spent years building their brand around a logo they thought they owned, only to discover during due diligence for trademark registration that they never actually acquired the copyright ownership from the designer. What a last-minute headache to resolve. And worse, what if the designer won't transfer ownership? For every contractor who creates copyrightable work for you, designers, writers, photographers, videographers, developers, etc., you need a written agreement that includes the right copyright language assigning copyright to your business. For my copyright action list, use the free downloadable and printable checklist on my website at kingpatentlaw.com. Now we'll talk about patents and trade secrets, which are less common for most small businesses, but if you have them, they can be extraordinarily valuable. A patent gives you the exclusive right to make, use, sell, or import an invention for a limited time, which is usually 20 years for utility patents and 15 years for design patents. If you already have patents or patent applications, here's what your audit needs to cover. Number 1, are your maintenance fees current? Utility patents require maintenance fees to be paid at 3.5 years, 7.5 years, and 11.5 years after the patent is granted. If you don't pay them, your patent will expire and will enter the public domain. Often, a patent lapses because the owner didn't have a system for tracking maintenance fee deadlines. The owner may lose exclusive rights to a technology that was generating significant revenue. Once a patent lapses, you can't get it back. So check the status of all your granted patents on the USPTO website. Whether maintenance fees are due in the next 12 months, whether you have a calendaring system to track future deadlines. If you're not sure when fees are due, hire a patent attorney or patent maintenance service to manage this for you. The cost is minimal compared to losing your patent rights. Question 2 is, are your pending applications being tracked? If you have patent applications in process, which means they're not yet granted, there are critical deadlines you cannot miss, such as office action, response deadlines, continuation in part, or divisional application deadlines, and foreign filing deadlines, which are usually 12 months from your U.S. filing date under the Paris Convention or 30 months under the PCT. Missing a patent office deadline can kill your application, and there may be no way to revive it. If you're working with a patent attorney or agent, they should be tracking these deadlines, but verify they are ultimately your responsibility. Send an email asking for a status update on all pending applications and upcoming deadlines. Question 3 is, have you created any new inventions worth protecting? Think about what your business developed in the past year. New products or product improvements, new manufacturing processes or methods, new software algorithms or technical solutions, new designs or ornamental features. Not everything is patentable, and not everything that's patentable is worth the cost of patenting, given that utility patents cost $10,000 to $20,000 plus to obtain, and sometimes much, much more. If you've developed something innovative that gives you a competitive advantage, it's worth at least having a conversation with a patent attorney about whether patent protection makes sense. And let's look at one critical timing issue. You have 12 months from the first public disclosure, offer for sale, or use of your invention in the public to file a U.S. patent application. After that, you just lose your U.S. patent rights forever. For international patent rights, many countries require you to file before any public disclosure. There's no grace period, and this is why non-disclosure agreements are incredibly important while you're developing an invention. If they're done properly, they keep disclosure to the people or businesses who sign them from being counted as public disclosure. Now, if you publicly launched or disclosed a new product or technology in the past year and haven't filed a patent application yet, talk to a patent attorney immediately to see if you're still within the filing window. Now, sometimes patents aren't the right way to protect an invention, or you have other IP that doesn't really fit into the patent, trademark, or copyright category. Now, for that, we have trade secret protection. A trade secret is any information that derives economic value from not being generally known and is subject to reasonable efforts to maintain its secrecy. Classic examples include the Coca-Cola formula, Google's search algorithm, KFC's blend of herbs and spices, customer lists and pricing strategies, manufacturing processes and techniques, and proprietary business methods. Trade secrets can last forever as long as they remain secret, but once they're publicly disclosed, you lose all protection. Question number 1 to ask about trade secrets is, what does your business have that qualifies as a trade secret? Think about information that gives you a competitive advantage, like recipes, formulas, or chemical compositions, manufacturing processes or techniques, software source code or algorithms, your customer lists and contact information, supplier lists and pricing, marketing strategies and pricing models, or business methods and operational processes. That covers many things that are important to your business. Question number 2 is, are they actually secret? Now, for something to qualify as a trade secret, you do have to take reasonable steps to keep it confidential. That means physical security. Lock up those documents containing trade secrets. Restrict access to areas where secret processes occur. Digital security means password protect files, use encryption, limit access to trade secret information on a need-to-know basis. And then you have contractual protections. Use non-disclosure agreements or NDAs with employees, contractors, partners, and anyone else who might have access. And then there's employee training. Make sure your team knows what information is confidential and how to protect it. Clear labeling can help. Mark documents containing trade secrets as confidential or proprietary. Now, if you're not taking these kinds of steps, you probably can't claim trade secret protection. Businesses have lost trade secret cases because they couldn't prove they treated the information as confidential. If you email your secret formula to vendors without an NDA, post it in an unsecured shared drive that everyone in the company can access, or discuss it openly in meetings without confidentiality agreements, it's not a trade secret anymore. It's not even secret. Question number 3 is, do you need non-disclosure agreements or NDAs for the secrets? And if so, do you have them in place? Every single person who has access to your trade secrets should sign a non-disclosure agreement, such as employees, ideally as part of their employment agreement, independent contractors and consultants, vendors and suppliers who need access to confidential information, and potential business partners or investors doing due diligence. An NDA should define what information is confidential, specify how long the confidentiality obligation lasts, explain what the recipient can and cannot do with the information, and include consequences for breach. If you don't have NDAs in place, you're vulnerable. Get them signed this month. Question number 4 is, should any new innovation be protected by a patent or kept as a trade secret? Patent advantages include exclusive rights, even if someone else discovers it independently, public notice of ownership, ability to license, and 20 years of guaranteed protection, as long as you keep those maintenance fees paid. Patent disadvantages include being expensive, requiring full public disclosure, and having limited duration. Trade secret advantages are no filing costs, no expiration, and no public disclosure requirement. Trade secret disadvantages include that if someone else independently discovers it or reverse engineers it, you don't have any protection. If secrecy is lost, protection is lost. So the strategic question is this: can your innovation be reverse engineered? If yes, you probably should make sure you have a patent for it if you can get one. If no, trade secret protection might make more sense. So whichever is best, I'll remind you that you can lose both patent rights and trade secret protection rights if you're not careful. If you publicly disclose without filing a patent application within 12 months, you just lose the ability to patent it. And once it's public, it is no longer a trade secret. For the patent and trade secret action checklist, download or print the free IP Checkup checklist on my website, kingpatentlaw.com. So now we come to the conclusion, which is that IP protection is an ongoing practice. Identifying and protecting your business's intellectual property isn't a one-time task. It's really an annual practice at the least. Your business evolves. You create new content, launch new products, or expand into new markets. Your IP portfolio needs to evolve with all of that. That's why an annual IP audit matters. It ensures your protection keeps pace with your growth. Many IP lawyers, including me, offer IP audits, but there is a lot you can do on your own. Next week, I'll be looking at the Entityville horror, which is how to choose the right business structure, LLC, S Corp, C Corp, or something else. Because the entity you choose affects not just your liability, protection, and taxes, but also how easily you can protect and transfer your intellectual property. In the meantime, to review all your IP that I talked about in this episode, download the free annual IP Checkup checklist at kingpatentlaw.com or using this QR code so you have a step-by-step guide for auditing your intellectual property. If you discover gaps or problems during your audit that you're not sure how to address, or if you just don't have time to do it yourself, schedule a consultation at kingpatentlaw.com or call 217-714-8558. We'll review your IP portfolio and create a protection strategy that fits your budget and priorities. I'm Julie King with King Patent Law. Thanks for listening and watching. Avoid the legal horrors and keep rocking your IP. And here's your reminder that this content is for informational and educational purposes only. It's not legal advice and doesn't create an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney.